If your will can't be found, does it even exist? Hi, I'm Joel Beck of the Beck Law Firm, LLC in Lawrenceville, Georgia, and that's a good question. So this happens from time to time. Someone contacts our office wanting to update their estate plan, telling us they did some planning many years ago, but they can't find their documents. In other situations, attorneys sometimes hear from family members of someone who had deceased, but no one can find a will. But the family was sure that their loved one had signed one. Well, these situations raise an interesting question. If your will cannot be found, do you have a will? Well, in Georgia, that question is somewhat like a paradox, like Schrodinger's cat thought experiment. Maybe there is a will, maybe there isn't. It really depends on what is observed when you open the box, or in this case, when you open and go through the probate case. Let me explain. So initially, Georgia law presumes an intent to revoke a will if the original will cannot be found to be offered for probate after someone passes away. This seems reasonable because the individual may have torn up the original will as a way to revoke it or otherwise destroyed it because it no longer met his or her wishes. And this presumption of intent to revoke the will is set forth in paragraph A of OCGA 53-4-6. But paragraph B of that same code section provides that a copy of a will, meaning not the original itself, but just a copy of it, can be offered for probate, provided it can be proved to be a copy of the original. Maybe that's done through testimony or an affidavit of one of the witnesses of the signing of the will, and the presumption of intent to revoke the will is rebutted by a preponderance of the evidence. So if the original will cannot be found, but a copy is located that is proven to be a true copy, the copy can be probated so long as it is proven by a preponderance of the evidence that the person did not intend to revoke the will. But proving that there was not an intent to revoke the will may not be simple or easy to do at all. So what does this mean for you if you've gone through the steps to put together an estate plan to meet your wishes, including executing a will? It means that you need to keep your original will in a safe, secure location, protected from theft, from smoke, fire, and water damage, and you need to make sure that the right people know it exists and are able to access it once you decease. This also means that you control the distribution of copies of your will to others, maybe even not giving anyone a copy if there's a chance you might revoke your will at some point in the future, including a revocation caused by your signing a new will with changes to your plan. Finally, it may also mean that you want to keep a third party in the loop, such as your attorney or a CPA or a financial advisor or a trusted friend. Keep them in the loop with respect to any estate plan changes, including any time you revoke a will, so that if needed, this independent third party who's not inheriting from you in any way can provide testimony as to your intent with respect to your will in the event someone seeks to probate a copy of a will where the original cannot be found. Now, of course, while this topic might be somewhat interesting, it's really meaningless to those who've not done any estate planning, as there cannot be a true copy of a will that was never actually made. If you've got questions about estate planning for your situation, we invite you to contact us to request free information on estate planning in Georgia or to schedule a consultation to discuss your needs. Thanks.